we're looking at letters of representation. In my jurisdiction, we call it representasi, and I believe it is also called representation in surrounding jurisdictions, Singapore, India, Brunei, and if I'm not mistaken, Pakistan as well, among others. In other places, like in the United States, there's a certain terminology. I'm not really sure if this is correct. Proffer, a letter of proffer. Declination of charge. I'm not sure if these are correct, but I've come across that in my readings. We have requests to reconsider. That's used in some jurisdictions as well in the Commonwealth. What's the objective? It is an appeal, basically, an application done formally from the accused to the prosecutor's office, requesting for charges that have been filed against him to be reviewed. And the end game is so that the charge is dropped outright, resulting in the release. It could be an acquittal or a discharge not amounting to an acquittal. And this can be also substituted instead by a lesser charge, where usually the condition is that the accused pleads guilty. There could be also other conditions attached to any consideration by the prosecutor. For example, that the accused agrees to be a prosecution witness against somebody else, perhaps a co-accused or an accused in some other perhaps more important case. There can be also a requirement that the accused plead guilty and not object to other outstanding charges being taken into consideration. What it means is, let's say that there are some other outstanding charges, that these outstanding charges would be taken into consideration and this would be disclosed to the court. So the court would impose a heavier punishment for the charge that is being pleaded guilty to, and the outstanding charges are withdrawn. So this is part of the considerations that can take place. What are some observations about representation is that it is a safe way for an accused person to attempt to review or withdraw the charge against him. It is safe because the letters sent to the AG's chambers are done without prejudice. I will be discussing later how it could sometimes backfire or put an accused person to risk, where some prosecutors might take advantage of information offered. How it is nonetheless a good way for us to exit from a criminal trial with very little cost. However, the risk is something that should still be considered. When should a representation be sent? It can be sent before trial. This is the typical practice in my country. It is sometimes sent even before charges are filed while the investigation is underway. However, I would share my own view in some other video how this could be counterproductive. Representation can also be sent in the midst of trial, in the heat of battle, where it is most effective or most beneficial perhaps after an important witness has testified and if the testimony is damaging to the prosecution case. In those situations, one might wonder, or the defense might think, should they attempt a representation at that stage? Or should they risk going all out to trial and going for the kill with the confidence that the prosecution case has been damaged by such testimony? I would like to suggest that a representation should be considered at every opportunity possible because there is really nothing to lose. Some time back, I did come across a situation. I was a prosecuting officer representing a regulator, and my opponent sent a representation and actually copied the court. This is an unusual practice. Although I'm not aware of any rule that says that you can't do that, I don't think that it's proper to do so. What would be the reason to do so? Is it to put some pressure on the prosecutor or put some pressure on the prosecution's office to get them moving so that their representation is considered more speedily? In that case that I handled, I don't know, and the representation was eventually declined. However, I would imagine there could be a scenario where the defense would want to copy perhaps other prosecution officers higher up in the prosecution hierarchy of the AG's chambers, or perhaps they would want to copy any stakeholders, which I think it is not advisable, because a representation contains information that is very much private between the accused and the prosecution, which is given without prejudice. There could even be some information that the accused doesn't want even the investigator to know. For example, if he or she has information of some misconduct by the investigator, or perhaps something unethical by the investigation that they would like to bring to the prosecution's attention. So these are some of the early consideration that I want to share with you, good selves. I think persons who are under investigation or representing people who have been indicted, I think should consider representations with an open mind. When you send a representation, it doesn't mean that you are conceding that your case is weak. It just means that you are taking every opportunity to get the best outcome for the case that you are facing. Often the existence only of representation, but not the content, will be disclosed, usually in the course of a case management, when the prosecutor might inform that they received this representation from the defense, or the defense counsel would inform that they require another case management date before trial, so that the representation can be decided on. That could be like the only time that a representation is made public. Now, if you are on the side of some other stakeholder not privy to the communication, or if you are a victim or a complainant, I think generally, and I'm just being presumptuous, a result in favor of the accused might be against you, might be not in your interest. For that reason, if you are a complainant, let's say you're a company or you're an organization, it might be in your interest that you keep tabs on the developments of case management, and not only during trial. It is often the case that a complainant or a victim only knows about the case when they receive a subpoena, when the investigating officer calls them for trial. But no, even before that, there could be plea bargaining. There could be representations made by the defense. So get some advice. Perhaps there is a way for a legally represented complainant, victim, or stakeholder to intercept or intervene, so that they remind the Attorney General's chambers that hey, we exist. I'm still alive, and although they will not know the content of the representation, to at least remind the AG's chambers to consider their position on the charge itself. Especially when the charges were procured after much, can I say, out-of-court advocacy, much following up by the side of the complainant. Otherwise, the complainant may be in for a rude surprise, seeing the accused walking free in public because the charge against him had been surreptitiously withdrawn without the complainant being updated by the authorities. In my jurisdiction, Malaysia, and I expect it's more or less the same in many other countries that practice the common law system, how a charge is reviewed based on a representation is that upon receipt of the letter of representation, the prosecutor who's in charge of the file would send it to his boss, and his boss would give directions on it. sometimes the boss will assign the same prosecuting officer to prepare a write-up together with his assessment of the case as well as assessment of the representation. These are two different assessments, all right? Alternatively, his supervisor might refer the matter to another prosecutor to review, and there could be some administrative or some other practical reasons for this. For example, in the AG's chambers, there are so many departments, so many branches, so many units, supervising tens, dozens, or nowadays, I don't know, hundreds of prosecutors all over the country. I'm not aware of the exact amount, but when I was posted there in Putrajaya, there was some 70 deputy public prosecutors, that's what we call them, at the headquarters of AG's chambers. And there are specific specialized units with officers who day in, day out, they review investigation papers. At that time, izin, pertuduhan, consent applications from various states to prosecute cases of drug trafficking and murder. So these units at headquarters, their officers are specialized for that area of law. And because they day in and day out, they review and they consider representations for those categories of cases all over the country, they have a bird's eye view of what are the policy expectations of AG's chambers in respect of those categories of cases. So just because the state level prosecutor or the agency level prosecutor might have a view of your representation doesn't mean that it is agreed by the AG's chambers. There is an hierarchy within the prosecution service in our country, in many other countries as well, and the higher the office, the more its ability to overrule and to change a decision made by an organization or department that's lower in the hierarchy. So one of the criteria that I want to give an example is the amount in consideration. So we're not talking about corruption cases, which are the purview of the Malaysian Anti-Corruption Commission or other specialized agency. We're talking about generic commercial crimes such as cheating under section 417, 420 of the Penal Code. We're talking about drug trafficking, 39B of the Dangerous Drugs Act 1952 and others of the like, CBT, things like that. So if the amount is if the amount of loss or the amount of misappropriation or the amount of impugned monies defrauded, it reaches a certain threshold, thus it will be referred to headquarters, and it is not for the state level prosecution team to decide. So some time back it used to be like 1 million ringgit, and then it was increased to 3 million and then 5 million. So over time it keeps getting higher and higher. So as of the date of this discussion, 2025, I do not know what is the threshold. Sometimes, even if a case does not reach the threshold, however, if it is considered important enough, it is of public interest, or if it is of certain poses certain challenges or difficulties, technical difficulties, then the state prosecution team, now is called Pengarah Pendakwa Negeri, the Director of Prosecutions. My time it was called the Ketua Unit, the Head of Unit. They would refer it to headquarters, notwithstanding that the case should have been decided by the state. So, what happens after this officer has received the instruction to consider the case? They will consider the case as well as the representation. Because sometimes, to start with, the representation might not be that meritorious, but the case might have problems already, and the prosecution might decide to withdraw the charges, notwithstanding the representation does not provide good grounds. So even with a weak representation, you might get lucky and the case might still be dropped, because at that point in time, the prosecutor realizes that there are some problems with the case. Now you might ask, why didn't they decide to withdraw it earlier? Why did they have to wait for a representation to be made? This is not an easy question to respond to, I'd just like to speak from the perspective of a practitioner, and I just like to offer this view as simply as I could. When there has been a charge filed in court, the decision has been made by the prosecution service. So many things had gone into it. So due to the integrity of the service, due to accountability, they cannot just simply withdraw the charge on their own without representation being made. Some officer somewhere had signed the minute directing the authorities to draft and file the charges, or they themselves drafted the charges. Somebody had been briefed, had addressed his or her mind, and had made that decision. So if they withdraw the charge on their own, they have the power to, under our Article 145 of the Malaysian Federal Constitution. Surely they have the power, but how would it look? How would it reflect? And would that open the government, whether the police or some other bodies, to suits of malicious prosecution or some other civil action following the decision of the federal court in Sundaraju? I think this is something that should remain a concern to us. So sometimes they do wait for a representasi as a, well, just to use this term, an imperfect translation, a lesson for them to withdraw the charge. So the decision to continue with the charge or to withdraw the charge might have something to do with what you said in your representation, or it might have little or even nothing to do with what you state in your representation. It could be that, on the other hand, the representation is meritorious and does provide good grounds, but for special reasons, they still have to proceed with the case. There could be policy reasons. It could be based on, for example, just the weight of the drugs, even though another case with identical facts, but if the amount of drugs were different, it would affect the outcome of that decision on the representation. These are policy matters, and these are not in the public domain. We do not know. We can make assumptions, but we do not know. Hence, representations are something which you just gotta do. You just do it, you tawakal, you leave it to the Almighty, you take a leap of faith. You do it in a measured, calculated, strategic manner, and it is done with the right timing for the right purpose and requesting the right outcome. So it's not really an exact science, is it? Sometimes you go with your gut feeling and you just do it. There are so many hands involved in the process. There's the officer who received the representation, the one who's looking into it, the supervisor. The decision to consider a representation, to accept or to reject, may lay with the supervisor of this prosecutor, or as I mentioned, if it is or reaches a certain category or threshold, they have to refer it to headquarters anyway. On the subject of the feedback and the response, you will receive a response to the representation. At the very least, you should receive a response in writing that they are still considering it and will need time. Of course, you can't say how long it's going to take them to respond to a representation. They might take their time. I mean, it's they have a lot of work. They have other cases, new charges to consider. Perhaps the sense of urgency would arrive if they know the trial is coming soon, or maybe something extraordinary has occurred, like a witness has died or something, or one of their important witnesses has been impeached. But I would like to think that, and this is just my personal view, I can't rely on any independent law on this, is that the considerations of winning or losing the case is not the priority for our prosecution service. It's not. Yes, for a private practitioner, it very much is. But for the prosecution service, it's really about discharging their duty in accordance with law, to prosecute fairly, to conduct their work ethically, to prosecute fairly. That's their duty. Now, does that also does that affect their considerations in representation? By right, conducting a case also includes reviewing a case when there is a representation. I'm sorry, that I don't know. I can't say. What I like to say is that besides the policy considerations that I mentioned just now, sometimes it's a personal matter. I mean, soal nak ke tak nak, rajin ke tak rajin. Because as I mentioned, in the reality, the day-to-day functions of a prosecution service, they have so many functions and so much work to attend to. Sometimes they just don't have the time to look into your representation. But that doesn't mean that you give up. You don't. You got to do it. And if you don't get a response or an answer, you keep trying. But don't keep sending the same representation again and again with no new content. Let's say that you send a representation and it has been rejected or declined, or they don't consider. Don't keep sending the same thing. When I was a prosecutor, I remember there was one case, and they had two lawyers, and they sent like 6 representations, and the content did not change much. And it was curious. I mean, was it Einstein who said? Was it Einstein? What's the meaning of insanity? Repeating the same thing in the same way each time and expecting a better result. Sometimes you just can't give a good representation. Sometimes your client just doesn't have a good case, doesn't have a good basis. Or sometimes the client's defense can only be best expressed in trial. So sometimes memang tak boleh. Sometimes you just gotta go for trial. Regardless of what you think, of what your client thinks, sometimes the way forward is a trial. So if your representation is rejected or declined, as I mentioned just now, it doesn't mean that it's not meritorious or that you did meet. Okay, so let's say you disagree with the outcome of a representation, and I think this could apply whether you're on the defense side or even if you are on the side of the victim. It's kind of like appeal. You can write an appeal to the officer or the department that is higher in the hierarchy, as though it is an appeal from a decision of, like, from a lower court to a higher court. But of course, it's not like a proper court appeal. Of course, not done that way. It's just a letter. But of course, in the tenor of your letter should be courteous, respectful, because the ball's all in their court. They have the nearly absolute discretion to determine what happens to the charge, whether it's to proceed or it's to be dropped or it's to be amended. And so you better be nice. Don't make personal attacks or institutional attacks against the prosecution. They're just doing their job. Your case is just like one out of many. Your representation is just one out of many. But don't lose hope. What does a reply from the prosecution look like? Just now I mentioned that they might give you a reply in writing, right, that they're considering. But how about the actual result, whether it's rejected or not? It can be that the prosecutor comes to court and just mentions orally that representasi ditolak. Representation has been declined. The object of a letter of representation is to persuade the Attorney General's chambers to review an ongoing charge against you or your clients, because it involves input from an outside source that is not from the enforcement agency or within the prosecution body. A certain level of introspection is required. What I mean by this is that the first barrier to be overcome is the very fact that a decision to charge had been made. And in arriving to that decision to charge, resources, time, energy, a lot of thought had been committed to produce that charge. And the government agency does not take it lightly. They do not want to be seen to be inconsistent, to be withdrawing or reviewing charges on a whim, or making mistakes.
That does not bode well administratively, and it can open its offices to civil suits. We also take for granted that the law gives much latitude to the discretion of the public prosecutor to prefer charges. Therefore, it is a big deal to persuade the Aegis Chambers by way of a letter of representation to review its charges. The approach that is recommended typically is not to just put your arguments forward and demand, because you don't get to demand, you don't get a review of the charges as of right, fat chance. Indeed, it is expected that we put our best foot forward, the best arguments forward, facts and in law, the usual narratives. But I think that from observations of successful and unsuccessful representations, it just lacks validation. You don't know whether the charges were indeed reviewed for your representation, if at all, or if it was, what part of the representation, what argument. I think just give good reasons, make it an easy decision for them to review the charge against you or your client. Don't put up complicated theories, complicated conspiracy stories, twisted narratives, things that are too complicated. Keep it simple and get to the point. Kind of like a submissions, except that for those factors that I told you about. You need to overcome the fact that a decision had been arrived. When you are requiring them to review the charges, state clearly what you want of them. You want the charges to be dropped, to be reduced. Offer yourself or your client as a witness against whom. Specify whom. And this, we hope, can procure a good result for you, whereby you can get the charges withdrawn, you get a successful result without ever having to go through the entire trial and its attendant risks. Sometimes you're going to get cases that are watertight, strong evidence against you or your client. Sometimes there are cases that are poorly investigated. You might be able to get yourself through some evidential loophole, some gap in the prosecution case. And less common, but something that we hope you have an actual defense. And this can be in the form of not just casting doubt or poking holes in the prosecution case, but actually having a substantive defense that can either establish a statutory defense on a balance of probability, or to put something clear, something substantive that can be proved by independent evidence. So in those scenarios, these are things which you need to make a judgment call. Do you want to put it forward to the prosecution in your representation? If you do that, in an ideal and honest scenario, take a leap of faith. They should instruct the investigating officer to verify your assertions in your defense, to take statements from the witnesses that you have named, to seek out, confirm and obtain those other evidences and informations, phone records, etc. that you have put forward. And of course, the sooner you do this, the better, because evidence degrades over time. Take this leap of faith, and if the result is in your favor, hopefully the prosecution team among themselves may speak to their superior and say, the accused has a defense. We can't proceed like this. A prosecution team worth its salt would insist that the public interest justifies that investigations be carried out to see if they can deal with, refute or overcome this defense that you've put over. So they might order further investigations be carried out to check out these claims that you've made. So if you put forward witnesses who are neutral or somewhat removed from the accused, there's a possibility they might feel intimidated. They'll get summoned for statement recording. So some defense teams, they secure them by way of statutory declarations. This may or may not work. There are pros and cons of this, which I won't get into. On the other hand, sometimes you can't trust them. When I say you can't trust them, it does not impute any unethical or dishonesty upon the prosecution. That's not what I'm saying. I'm not saying ill of them. I'm just saying that you can't rely on them to fight for your defense, to go out of their way to put in the proper write-up, to put forward your arguments as cogently as you could if it was your own case. After all, they are disinterested in your case. They just your case is just one out of many cases that they are handling. So can you rely on them? Can you trust this information to them? Sometimes you have no choice. The alternative being is just to not put forward your best arguments, in which case your representacy might have nothing to it, nothing much to it, it'll get rejected, or just go for trial. On the other hand, sometimes the defense that you want to put forward is in that twilight zone, in between, in that point that do you want to share this information or not? Because what if the prosecution, they investigate your defense and they find a weakness in the defense you put forward? Therefore, daripada tak tahu, dia orang tahu. So should you just save it for trial? This is a judgment call you need to make. Some defense teams, they take a layered approach. They give the first line of representation, the first line of defense. Orang kata throw away defenses. But there's the nuance and the layers, the substantiations, the real gut of it is safely kept away, unless of course called upon by the prosecution, because concealing material evidence could be an offense in some places, in some contexts. So this is a judgment call you need to make. Can you imagine when you are handling a trial, there are advantages to putting the defense forward for the first time. Then of course the disadvantage is afterthought. But afterthought doesn't arise when you put it in a representation, because it's off record. So what do we do? Sometimes it is insisted that this defense, this special defense I might say, is disclosed in the accused witness statement during investigation stage. Or, referring to the case of Ui Chu Hock, the Court of Appeal, it is put forward to the investigator by way of an SD and a request that it be investigated. Thirdly, sometimes the statute requires it, like a defense of alibi. You might also want to put in, either through the suspect statement or by way of a lawyer's letter, as in the case of Maria Elvira, there's what they call an Alcantara notice. The law is still developing on that as we speak. We can put through notices to produce documents which suggest the defense, and failure to produce those documents can be somehow used in your favor if you can use it properly. But it has to be within reason. I mean, there are case laws to say that the prosecution is not obliged, is not duty bound to help the defendant out, to bail them out. Of course, there are other case laws to show that a case must be conducted fairly, an investigation must be conducted fairly. So you got to do your research on this and weigh the benefits and the risk on disclosing that defense. Timing is key. Some things is okay to disclose late. Like I said, in the dynamics of a trial, afterthought doesn't always hurt the defense always in the same way. It depends on the source of the documents, whether it's readily available and accessible to the prosecution with some reasonable diligence. Like I said, you just gotta read it. You gotta read the case law. However, it doesn't beat resolving this through a representacy, because when you can close down a case through representation, I mean, you take away the risk of trial. Another downside of representations is there is no not to say no accountability. There is no way you can compel the prosecution to give you a result. So sometimes accused persons, suspects, clients, they get stressed out because they're not getting response from their representation. What does it mean there's no response? Does it mean that my defense is poor? We can't say for sure. But what we can say is that there is an e-representacy system. They're obliged to consider fairly representacy. But like I said, those introspective factors, they can't just revisit or change the decisions on a whim. And they might consider that your grounds are frivolous. Your grounds are not good enough. Okay, in what situation must the prosecution actually react and respond? A representacy is a good way to kickstart the formal statutory plea bargaining procedure, which we can see in the Criminal Procedure Code. It's a good way. And the prosecutor will be summoned, and they have to show up. And it's overseen by the judge, so the prosecutor tak boleh buat tak tahu. They cannot just shrug off your representation, your plea bargaining application. Do it formally and consider that. Now, whether your application is made in good faith, I leave it to you. Ethically, you should do all your actions in good faith, because we have integrity of the administration of justice and your own personal reputation at stake. If you start doing things in bad faith, word will go around, the courts will know your name, that this is the scummy guy who tried to game the court and the prosecutor, messing around with the plea bargaining procedure. You don't want to be known for that. That will just jeopardize your interest. So keep an open mind that representations is just one more item in your arsenal, and it is a ticket to a speedy conclusion of your case, if it works.